Very good morning to all of you, and a very, very warm welcome to the postgraduate lecture series on key issues for advanced research in criminal procedure, some reflections. Ladies and gentlemen, we have Professor Dr. Khagesh Gautam with us, who's a professor of law with the Jindal Global Law School, OP Jindal Global University, Sonipat, India. I would now request Professor Murthy, our Vice Chancellor and Dean School of Law, to kindly give his opening remarks.
Good morning. I want to extend a warm welcome to Dr. Khagesh Gautam, a dear friend of mine and an esteemed colleague. And we worked together for several years, and I have very fond memories of our association. And I happened to see a manual or a case book compiled by him while doing a course on constitutional law at Jindal Global Law School. I was deeply impressed with that, and I have traveled with him to Chandigarh for meetings with regulators, and where I saw at first hand his what you call remarkable abilities in presenting a case cogently before the Department of Higher Education, Department of Technical Education, Government of Haryana. And Dr. Khagesh is a wonderful scholar, having written extensively and published in both national and international journals, and with excellent credentials, having secured degrees from Columbia University and the Indiana University. And so we are eagerly looking forward to hearing from Dr. Khagesh. Once again, warm welcome to Dr. Khagesh. Thank you for accepting our invite. And
thank you, Professor Murthy. For the benefit of our audience here, also, Professor Khagesh, we have a lot of students who are postgraduate students, who not only are students, but also those who have joined from outside, colleges, who are pursuing their postgraduate course with different universities. So a very small brief profile about Professor Khagesh. Professor Khagesh was awarded SJD from Maurer School of Law, Indiana University in May 2021, where he finished his doctoral work in record 611 days. Now, Professor Khagesh, this is what made me look at your profile in awe. When I saw the 611 days, his doctoral thesis argues that constitutional validity of Section 27 of the Indian Evidence Act 1872 is suspect on the grounds that it violates Article 23 of the Indian Constitution. Dr. Gautam graduated with distinction as a Stone Scholar from Columbia Law School in May 2013, where he obtained a LLM and received his LLB from Campus Law Center, Delhi University in June 2008. He has appeared before the Supreme Court of India, Delhi High Court, and Punjab and Haryana High Court. He is currently on the faculty at Jindal Global Law School as a professor of law, where he teaches constitutional law, criminal procedure, and evidence. He has also taught comparative evidence at China University of Political Science and Law, Changpang, Beijing, and comparative constitutional law at William S. Richardson School of Law, University of Hawaii, USA. He was also awarded the Legal Professional of the Year at the first India Hemp Expo on May 2022 at New Delhi. This is only a very small brief of Professor Khagesh. All our audience, I would request all of you to please go on to his LinkedIn profile. We have much more, waiting on his credentials. Over to you, Professor Khagesh.
Thank you, Arpita. Thank you, Dr. Murthy, for that very kind introduction. I do remember that very fruitful visit that we had. I was in question for a while there, if I'm able to explain it properly, but such is the nature of regulators. But thank you so much for your kind introduction. And of course, I joined in Jindal in 2013. I've been here for about 10 years now. And Mr. Murthy was the registrar, and he was leading us in many capacities, and we still miss him. It's our loss, but it's our university's huge gain. So we are still missed, sir. You're still remembered very fondly by all of us here. All of us who still remember you. Many of these new kids, they don't know what they're missing.
Yeah.
Right. So thank you for having me. So coming to today's topic was advanced research on criminal procedure, some reflections. So I'll speak accordingly. I'm not presenting any paper as such. I've written a little bit about criminal procedure, though that's not what I started. When I started working at Jindal, I was predominantly focused on comparative constitutional law. If you look at my writings in the earlier part of my career, when I was assistant professor and later associate, most of them are on random areas on constitutional law, but most of them focus on the issues of federalism. I've written about taxation. It is only after I taught comparative evidence for the second time in China, in Changping, I was fortunate enough to meet with some professors who were teaching in US. Most notably was Professor David Siegel, who teaches at Boston Law. Professor David Siegel is also a member of a committee of some sort of the Supreme Judicial Court of Massachusetts, and they're working on a restatement. That's how I was exposed to the idea of restatements, though I was roughly familiar with what a restatement is. I had never actually read one. So I learned that there is a different way in which criminal procedure is taught. Now, this begins in 2016, and then moving on in 2017, I had a chance to spend about 6 weeks in Hawaii. And there also I met with a few professors, I think John Barkai most notably, but I spoke with a few professors, and what I noticed was that there was a very big difference in the way CRPC is taught in the US. It's a very important point for all of us to notice, because since my law school days, I've been practicing criminal law at the bar, but I was not into teaching it. My teaching areas were always constitutional law, and taxation for a brief while. My interest awakened in the sense I realized that when we say in India that what we teach in law school and what is actually being practiced at the bar are different, and that's a problem that most people talk about. That you can't really teach criminal procedure, you can't really teach criminal evidence, you can't really teach somebody how to cross-examine, you can't really teach them. I for the longest time thought this was the case. Then I realized why this is the case. I believe this is the case because we in India have not developed any systematic way of thinking about criminal procedure. This is the reason why we are not able to teach it effectively. I'll give you one example. So if I ask a very fundamental question, and the question will sound philosophical, but it's very important to answer these philosophical questions. If I ask a question, what is criminal procedure? I think 9 or 8 out of 10 participants here, and you can replicate the survey in your classrooms, you'll find, you can ask your friends, you can replicate this in your life, you'll find most people will stop at the Code of Criminal Procedure of 1973. That's where they'll start, that's where they'll stop. So when we think about studying criminal procedure, most of us only think about the Code of 1973. We don't think beyond that. If you look at the decisions of the Supreme Court, you will see that the Supreme Court of India doesn't think that way necessarily. If you carefully look at, this is an exercise that I've done, but it's replicable, it's testable, anybody can test it. So we'll talk about facts. So this is an established fact that most of us, when we think about studying criminal procedure, think about the Code of Criminal Procedure of 1973. That's where our imagination starts, that's where our imagination stops. But the Supreme Court is a step ahead, and that's what most of us haven't realized. The Supreme Court of India in the year 1973 and almost up till 1982, 83, 85 crossed over a lot of like the judicial position that was the laid down law in 1898 carried forward. So the same interpretation of key provisions carried forward to the extent some procedural changes were made in the trial procedure in the Code of 1973. For example, committal proceedings were reduced to a merely formal proceedings. So to that extent, whatever was the interpretation of committal law couldn't carry forward, but it was replaced by some other law. But if you then, so what happens is there is this mystical creature called the doctrine. This is purely judge-made law, which is, of course, a gloss and interpretation of the principles originally codified in 1898. And we have a very long time period from 1898 till 1973. It's about 125 years now, compiled 50 years since the code. So we have a very long gestation period in between, where a lot of law was laid down by the Supreme Court or the Privy Council that was accepted by the Federal Court of India, later accepted by the Supreme Court of India. These are essentially judge-made principles of procedure. They will not find any, you will not be able to find any equivalent in the statute. I'll give you one example. The Supreme Court has said, like, the process right now is that an FIR is registered, investigation continues, investigation is completed, a charge sheet is prepared, charge sheet is then presented before the magistrate. Magistrate will then have to decide whether the case will be committed to trial for the sessions court, or the magistrate can proceed with the trial. That's the process. Almost everybody is aware, because that's what it's laid down in the code very clearly. There is one step of procedure which is not laid down in the code, which is laid down by the Supreme Court of India in Bhagwant Singh's case. Justice Bhagwati in Bhagwant Singh's case says, it's 1982 or 83 case, where the law is that after the charge sheet is received, the judicial magistrate is duty bound to send a copy of that charge sheet to the victim or the first informant, so that they could come to the court and file whatever objections they have. For instance, as police, I might have, the FIR might have had 8 potential charges. I might have only charged 4. Or there might be 3 people named in the charge sheet. I might have charge sheeted only 2. You could still have objections like that. So that is a step in procedure that is nowhere mentioned in the code. But it's laid down by Justice Bhagwati by the Supreme Court. And it is followed. It has to be followed, because if that step isn't followed, proceedings are vitiated. I'll give you one more example. After the trial is over, at the stage of sentencing, again a law laid down by Justice Bhagwati, judgment's name I don't recall in this moment, but I can give that to you later. The law, the code only says that after the trial is over, you have to pronounce on the guilt, a judgment has to be given, and if the judgment finds guilty, you have to then proceed to sentencing. So sentencing is, now the question was, is sentencing to be immediate, or has there to be like a detailed hearing to find the right quantum of sentence? For the longest time under the old code, the interpretation was it could be immediate. You can pronounce the sentence immediately. Immediate pronouncements of sentence makes a lot of sense, because the trial in the 1898 code is originally a jury trial. The 1898 code is written with a jury trial in mind. There was a provision for jury. Jury trials were continuing in India almost up till 1969. Only after 1973, when formally the code is there, jury trials are abandoned. So you have to understand that the laws that we are carrying over, the interpretation of which the Supreme Court is carrying over, were written with a very different context in mind. And I'm not talking about, I'm not using some colonial theory, though of course that's a separate point. That of course is a very important point, but then we'll have to go into history. I'm sticking only to jurisprudence. You have a very different type of trial envisioned. In the 1898, we don't have that. We only have bench trials now. In a jury trial, there is no need to pass a judgment. The jury pronounces and the judge only passes on the quantum of punishment. Now, Justice Bhagwati in this other judgment says we can't have that under the constitutional context that we have right now. The phrase "hear the accused" in the relevant section that pertains to judgment means the accused has the right to lead evidence that shows what is the right quantum, of course, because guilt has already been pronounced, so you can't have that again. But witnesses as to what type, how much punishment would be appropriate. This is a very important step in the procedure when the prosecution is asking for capital punishment. And this, again, the phrase "hear the accused" interpreted to mean the accused has the right to lead evidence is again a judicial interpretation. The law doesn't necessarily mean that. For the phrase "hear the accused," when is the same phrase used in section 227, which talks about discharge in the case of a sessions trial, where the Supreme Court has said that "hear the accused" in the case of discharge does not include the right to lead evidence, which of course it shouldn't, because if I'm to be discharged, I'm to be discharged based on the reading of the charge sheet and the supporting material. So you can see there are very many nuances of procedure, and I haven't, like, these are completely an interpretation of the Supreme Court, which should make us immediately aware that there is this mythical animal called the doctrine, an assimilation of principles inferred, synthesized from the case law. This doctrine is like the underground river Saraswati. It goes, it's always there. You have to be very perceptible to sense it. So what we have in India is we have a fundamental disagreement, or a lack of, not a disagreement. A disagreement means there has been a debate, a lack of clarity, a lack of debate even on what CRPC actually means. What is CRPC? Is it just the code? Is it the gloss put on the code by the Supreme Court, which I'm calling the doctrine, judge-made law? Is it a compilation of a lot of principles culled out from a lot of laws? What is it? And then the question is, well, what purpose is it serving? Is it there so that we can punish people, or that we determine guilt, or we fasten responsibility, or we resolve disputes, or we maintain law and order? What exactly is this thing doing in our system? These are very, very fundamental questions that are the core domain of advanced research on criminal procedure. Anybody interested in criminal procedure, advanced criminal procedure research, has to realize that if you look at it not too complicatedly, if you look at it simplistically, you can think of research as basic and advanced. The basic research is basically the study of the doctrine. I'm calling it basic. Don't think it's not complicated. It's a lot of hard work to read a lot of judgments and to synthesize and to infer from them principles of law that follow. It's the fundamental job of a legal academic. Anybody interested in any type of research in CRPC has to take basic research very seriously. In our country, unfortunately, we haven't done that. If you look at our textbooks on CRPC, they are all outdated. Not one of them is actually of much help, of much value in classroom teaching. Ratanlal Dheerajlal was a commentary that was originally written with a practitioner in mind. It hardly serves any purpose. It serves the purpose of decoration, but beyond that, I doubt what purpose it actually serves. We do have some useful textbooks, but they also need to be updated. So that job hasn't been done in India. That's where I was inspired by the idea of casebook. So Dr. Murthy will be happy to know that there is a casebook on evidence, and there is a casebook on criminal procedure as well, that I'm working on. And well, I'm using them here, and I'm happy to share those materials. But what happened, it wasn't, the idea was not to prepare a casebook. Idea was to prepare a list of canonical cases that have been cross-cited so many times that we can fairly say this is the core of our doctrine. And that exercise was conducted in evidence, criminal evidence mostly, and that exercise was conducted in CRPC, and I was able to come across, like, there is a list of 52, 53 core cases that we teach here that pertain to the stage of investigation, inquiry, trial, and sentence, after that conviction, and after that the special death reference process and the appellate process that follows. So the core of the case law, 47 or 48 cases are in the area of investigation, inquiry, and trial, mostly in investigation. And a huge component of that is 482, which is something that we do not teach, which is of course impossible to teach in a core course on CRPC, because 482 is way too advanced, for which I was, circumstances forced me, and ultimately we were able to come up with an elective course which I'm teaching now and the next semester, also called Advanced Criminal Procedure Pre-Trial Litigation, where we focus on litigation that happens before the trial even begins, which is a very important part of the practice of CRPC. but there is no way to actually teach it because there is no systematic way to think. So if you divide it, basic research is mostly about compilation of canonical cases, synthesizing from those canonical cases the principles of law so that we have clarity. I've attempted an exercise like this. I've shared an article where a brief restatement of on law of admissibility was I attempted, and I summarized the whole thing in three principles, three propositions that follow. It's liable to be critiqued, liable to be studied. Of course, it's just an attempt. It's like Wikipedia. People keep on adding and keep on adding to it. It's restatement writing is like writing an Upanishad. There is no one author. Somebody composes some hymns, somebody else composes some others, and over a period of time, a document emerges, and that document then becomes the key, the place that you go to. So that's basic research. Advanced research is not possible until basic research is of good quality. So that's where we all need to focus. But if one wants to go a step beyond and think about advanced research, I think one good way to think about advanced research would be to think of it in interdisciplinary perspective. And that perspective, of course, Dr. Murthy is very well aware of, because he has built a big part of his life and contributed a lot of effort to building that system here. So I think Dr. Murthy is the person to connect with this idea the most deeply. You will see that when you think about basic research, you want a body of doctrine. So most of the work you're doing is doctrinal. It's related to case law, how to read a case, and so on and so forth. You can add comparative perspective to it, but you still remain at basic level. When you go to advanced level, your perspective is not legal anymore. Your predominant perspective is not legal anymore. Your legal perspective is enclosed in another perspective, and it is enclosed. It could be enclosed in any perspective you want it to be enclosed in. You could enclose it in history, which I love the most, on which I'll speak about in a little while, some of the work that I've been doing. You can enclose it in economic perspective, it becomes law and economics. You can enclose it in sociology, it becomes sociology and law. You can enclose it in any other law, but remember that it is law that you're enclosing. So long as that thing is kept in mind, constitutional perspective also will not necessarily fall into advanced research because it's still doctrinal. It will fall in that stratosphere where you're just making your way from basic to advanced. So you have to go through the constitutional sphere in order to make it to the outer space of advanced research. That's the way I envision it. I think advanced perspective is very important, and I'll make a few comments on that. After that, I'll stop for any questions or any comments. So if you I personally have been looking at the whole thing from the historical perspective, and my question is, what is this being criminal procedure? The way I define it, criminal, if you think of it as a legal being, as a living, breathing entity, subject to the environment of law, the domain of law, I would say that criminal procedure is an amalgamation. I actually wrote it down, so I'll just read it. It is an amalgamated body of constitutional and legal rules. So you have to pick a lot from a lot of places, and then it becomes an amalgamated body of constitutional and legal rules, interpreted regularly by the courts. So doctrine, of course, is a part of it, whereby those accused of having committed offenses against the law are punished by the law through its courts for the sake of maintaining peace and harmony in a righteous society. That is how I would define what CRPC. This is the being. What is it made of? It's made of this amalgamated body of legal rules, constitutional rules, judicial precedent, and it can take whatever form we want it to take, so long as our objective is to punish people. So long as we want people punished by the law in accordance with the law through the courts of law, that's the principal purpose it serves is not punishment. The principal purpose this being serves is maintaining peace and harmony. And it will be able to do that if we have a righteous society. So there are two corollaries that follows from this. Nothing that threatens the peace and harmony of society can be declared an offense against the law. So it's a very serious being. We can't invoke this being unnecessarily. Legal punishment, you can see the moment anybody is FIR, if you're named in an FIR or you charge sheeted, you have the entire might of the state against you. You are in a very helpless position because you have to fight the state now. Your liberties are already curtailed the moment you're accused of a crime, more so the moment you're charge sheeted. Your liberties will be further curtailed the moment you're convicted and have served your punishment. It is a very serious weapon that we must use only where it is required. So we should be careful what we declare as an offense against the law. Any contemplation that takes you to the depths of what CRPC is will necessarily lead you to the realization that this is a very potent weapon. And it can't be turned against, you can't turn this against your own people. You have to be very careful about what you call an offense against the law. Second corollary that follows is everyone must be punished in a righteous manner. So you can't punish people in such a way that instead of making people believe in the idea of justice, instead of losing that idea, people must this goes down to a slightly philosophical reflection. My personal position is that the purpose of courts, purpose of judiciary, I'm talking about criminal justice system, but I'm taking a slightly bigger perspective here. The purpose of judiciary is not to mete out justice. Justice is far too volatile and vague a concept for any judge to define. Nobody has ever been able to define. You can only define justice relatively. Justice as a whole is a very difficult concept to understand, to define. So anything goes if you don't have a clear concept of what justice means. So justice as per law, justice as per rules, justice as per constitution is, you can control that volatile concept when you're thinking about it. I think the purpose of courts is not to give justice. For justice is far too big a concept for human courts to handle. I think the purpose of courts is to maintain the belief that people have, the faith that people have in the system. If judiciary as a whole stops acting in a manner which upholds the faith of the people in the system, and rather acts in a manner that gives people genuine cause to be unfaithful, untrustworthy of the system, then we are not doing it right. That is the only purpose judges serve, maintaining public faith in the system that we have created. So if you take that bigger idea and apply it to the second corollary, everyone must be punished in a manner that is righteous. You can immediately then draw other principles from it. Look, you can't, all the due process principles sort of automatically follow, but they follow only to the extent it is required. So this also gives you a very clear protection against being too comparative. If you become too comparative, then your search for answers will take you, of course, to the Fourth Amendment, to the Fifth Amendment, to the Sixth Amendment. But remember that those principles were laid down in those societies in very different contexts, in very different circumstances. They are useful in the sense they are inspirational. But whether they are completely migratable is where I take an exception. I don't think concepts like Fourth Amendment and Fifth Amendment are directly migratable. They are inspiring us, but we have to be, having once taken the inspiration, we have to figure out things for our own. And these are the questions that advanced research is most concerned with. We want to think about how the doctrine is the way it is. So to conclude my point and to focus on one particular problem, take the problem of custodial torture, for instance. Custodial torture is a very serious problem. Dr. Murthy has worked in the field of human rights for a very long time. Dr. Rajkumar here has worked in the field of human rights. And of course, we have scholars in RV University who are very familiar with the issue. It's a problem that affects the entire nation. It's a problem that affects the North, it affects the South, it affects the poor, it affects the rich, it affects the young, the old, it affects those who can't even vote. It affects everyone at a human level. The problem of custodial torture. Why has our republic not been able to solve this problem? 50 years have gone by since the 1973 code. Now see what happens. In the year 1860, legislative assembly debates were conducted. This is really, really back in the day. In these legislative debates, there was a huge discussion on Indian police. This is the beginning of Indian police. The Indian Police Act is enacted in the year 1860, if I recall correctly. And the first code of criminal procedure was enacted in the year 1858. 1898 is the 8th or the 9th code, if I recall correctly. This is all discussed in Lalita Kumari's case, the 7-judge bench, on default way, on registration of FIR. Now, in the year 1860, before we even had a police, the British are engaged in a discussion of should we have a police, a civilian police. And of course, nobody would say you should not have a civilian police. So the suggestion was that a quasi-military contingent, like a battalion of the then army, be taken and given these roles. And that's exactly what was done. What was happening before legislative assembly debates during the time of the First War, or some call the Sepoy Revolt, but it was a national, it was basically civil war. If you look at it from a military angle, there were battles all over the land. It was a civil war type of a situation. There was no police at that point of time. The political power, the Mughals had failed. The people don't have the power to community police in that sense. You had arms and ammunitions coming in, a lot of turmoil, a lot of chaos. It was important to have some order imposed, and the British decided to impose that order by creating a quasi-military type battalion that was given policing duties. And later on, these were the same battalions that were converted into state police regiments, which we today call the state police and Indian police on the whole. When these debates were being conducted in the 1860, one suggestion that was made very prominently was, do not give these officers the powers to record any statements that can be produced in court as evidence. It is specifically noted in the Legislative Assembly debates of 1960. Why? Because they will abuse these powers and they will extract confessions out of the people, and which will then be used to pronounce on guilt. The suggestion was made prominently by a lot of people. The suggestion was rejected. And then came the Code of Criminal Procedure, the first one, 1858, which had the same section 161, which we call 161 today, which is the power of the police to record statements in the course of investigation. Section 162 says that none of these statements will be admissible in trial, with 3 exceptions. One exception is a dying declaration, of course, because it's a dying declaration. Second exception is the use of section 145 of the Evidence Act, which is of course sensible because all these statements can be used by the defense. The third is interesting, section 27 of the Evidence Act, which basically says that if today Dr. Murthy arrests me as police officer and asks me where is the hidden, what did you steal? How much did you steal? Where did you hide it? Where is the dead body? And of course, he'll be very convincing in a custodial setting. So he's able to extract that information out of me. And I tell him that I stole a car, I stole this, I stole that, I hid the body there, the car is there. And he goes on a discovery hunt to see if I've given him correct information. And lo and behold, he finds the car hidden exactly where I told him, the body buried exactly where I told him, the murder weapon hidden exactly where I told him. And so he collects all this evidence, he bags all this evidence, he produces all this evidence. He goes to a judge and says, Your Honor, Dr. Khagesh Gautam, we arrested. We were suspicious. He gave us a statement in custody, and on the strength of that statement, we made these recoveries. We had no idea where these things are hidden. Only he did. He told us we went. Everything he told us is true. Look, exactly where. And then the judge is in a conundrum. Now, what is the judge supposed to do? Is my confession now reliable or not? This is a very, very, very big problem of Evidence Act. Now, who's to say? Dr. Murthy, of course, is an officer of integrity, so his investigation is reliable. But what if we find somebody of a little less integrity? They can reverse engineer the whole thing. This concern was first put in 1860, rejected, then noted by Lahore High Court at the cusp of independence by Justice Cornelius, the only Christian judge in the Pakistan judiciary, later on became a judge of the Supreme Court of Pakistan. Justice Cornelius, 1945, Lahore High Court notices the same thing, declares, reads the code of 1898, which is applicable to both India and Pakistan at that point of time, reads the code of 1898 to judicially create the concept of anticipatory bail, and we credit ourselves with creating that concept. It was created by judicial interpretation much earlier. Then the Law Commission report of 1960, same problem noted again. Law Commission report of 1969, same problem noted again. And what did we do? We took the same code and reenacted the same code. If the law was a certain way at a point of time and certain problems were experienced by the people, those problems are not going to go away if we reenact that law in different forms again and again. If the police were doing their investigations in a proper manner, if the police were well trained, if the police were professional about their duties, well equipped, then people of those times would not have faced the same problems. The fact that we are still facing the same problems is evidence of the fact that our problems are still the same. From 1860s till 2023, our problems are still the same. We do not know what to do with this police because the policing system that we have is imposed on us. It is not something that evolved out of the needs of our own people. Genuinely, it is not the case that Indian people on these lands were not living in peace and harmony before the British came or before the Mughals came. There are no such reports in history. People reportedly in these lands have been living with peace and harmony. It is inconceivable that people were not stealing, people were not cheating, people were not killing each other. It is inconceivable. All the books of the past, like spiritual injunctions of the past, say the same thing. Don't steal, don't cheat, don't lie. Why would they feel the need to say that if people were not cheating, stealing, or lying? So, of course, we had these problems like any human society does, but we also had a way to deal with those problems. We now have a system that we are not very familiar with, which is imposed on us, and we perpetuate the same problem. If you look at the 2023, the new CRPC bill, it's a valiant attempt, but unfortunately, this lack of ignorance of history results in the reenactment of largely the same provisions in different, sometimes even same form. So I think this much analysis enough for us to realize that there is a cycle of historical sort of trauma going on here. Every generation is traumatized by the same thing again and again, and until we are willing to go back in history and start at a certain point of time, we will not be able to fully understand exactly what is it that our criminal procedure system is based on, what assumptions it is based on, how it is supposed to act in practice, and what our expectations are. For instance, in USA, when students are taught that, criminal justice system, you can expect the system to behave this way, they can genuinely expect that because the system will behave that way. There is no distinction in theory and practice. In India, you can't teach people how to expect the system to behave, because you don't know how the system will behave. Is this to say system is unpredictable? No, the system is actually very predictable, but every prediction you make is against your client. So how are you going to serve? I mean, as an advocate, how are you going to serve your client? As a teacher, what law are you going to teach in class? So I think I'll stop the point here. We have no clarity on what this thing, this animal, this being is. We don't know its form. We don't know the substance it is made out of. We don't know in what circumstances it suddenly emerged. We don't know how to tame this animal. And I think we have to start with those questions that perforce makes the code of criminal procedure redundant. It makes the Evidence Act redundant. It makes the law of criminal procedure pertinent. And that law is not code. That law is a compilation of a lot of things designed to serve a very specific purpose. Now, I think I'll stop there. This is the fundamental question that must, I think, interest any advanced researcher on Indian CRPC in any jurisdiction of CRPC. And I think that's what we need to start really focusing on in our country. I'll stop now and take any doubts, like any comments or any questions.
Participants, if you have any questions, you can please unmute and ask Professor Khagesh. We have Professor Shantanu is here. Professor Khagesh, Professor Shantanu is a colleague here, and he heads the Center for Criminal Justice along with Professor Isha. So over to you, Professor Shantanu.
Thank you, ma'am. Thank you, Professor, for this wonderful lecture. Am I audible?
Yes.
Yeah, go ahead.
Yeah. So I have two questions, and I agree with your arguments. Firstly, that you have mentioned that the role of judges is to maintain and restore the faith of public, and not technically to give justice. There have been cases, specifically in death penalty cases, starting with Machi Singh, in which the judges have awarded death penalty only to restore the faith of public. They have extensively focused on collective conscience of the society as aggravating circumstance. And in recent years, in 2022, we have seen 165 death penalty cases awarded by the trial court. And in 2018, there were 162, and extensive use of aggravating circumstance like collective conscience in society. And so how judges are expected to focus on maintaining the faith of public, specifically in such cases. And also I would like to cite Professor Upendra Bakshi in his article, Law, Politics and Constitutional Hegemony. He argued that Indian courts are now inclined towards demosprudence, which is not precedent-minded, which is not like our jurisprudence, but regards the doing of justice or mitigation of injustice as its primary task. So this is first question, and a similar question would be that you have made a very strong argument, and I agree with that, that criminal procedure law is beyond CRPC, and obviously we should focus on constitutional provisions and jurisprudential aspects, etc. However, I argue that there has to be some kind of limit, specifically when criminal law has to be certain. So there has to be some kind of certainty, specifically in criminal law. Indian judges, specifically in death penalty cases, while exercising powers under 482 or while hearing sentencing, they have they have gone beyond the scope of 482 in many cases, and specifically in death penalty cases, they have cross the legal boundaries as has been laid down by the Supreme Court or other high courts. So judges have extensively referred in death penalty cases to holy scriptures as well. They have quoted Ramcharitmanas, they have quoted other Upanishads and Manusmriti for that case. So my argument is that there has to be some limit to how we are going beyond. So, thank you, sir.
So, Professor, thank you. That's a very good question. I think you make a very good point there. So to respond, I kind of not. I mean, I know the piece of writing that you referred to. It's a very famous piece of writing by Professor Bakshi. He's the doyen of all of us. With respect, I'd like slightly disagree. With greatest respect, I don't disagree. I think he and I are talking about the same thing. I'm just using different words. Now, I have written and I've studied most of my work is doctrinal, so I study a lot of doctrine. Now there are two pieces, like I wrote once an article which is relating to the taxation clauses of the Indian Constitution. It's just the taxation clauses. Now, when I read through the case law, most of them were 5-judge bench decisions, the Supreme Court decisions, and there was a remarkable consistency in the development of case law. Remarkable consistency. I was surprised. I was very proud of Supreme Court suddenly. It's like, wow, this is exactly now like it's supposed to be done. On the other hand, I have also studied the doctrine of Section 27 of the Evidence Act, which is the example that I just took, where I have found 4 different schools, all conflicting with each other, no clarity. Now, this means the problem is not with the court. Because if the problem would have been with the court, you will find the same pattern everywhere. But you don't some places you find remarkable consistency, some places you find complete mess that somebody has to come and take a very like deep look. This means so now if you go to capital punishment cases, you find the same inconsistency. I've spoken about it elsewhere. There's a long YouTube video. I won't go into that right now, but I think you see my point. There are areas, pockets where there's a remarkable consistency, pockets where there is not that remarkable consistency. That means the problem is also somewhere with the manner in which whatever is being done there. Most of the times what we find is that there is no anchoring principle. In capital punishment, there is no anchoring principle. For instance, rare of rarest cases doesn't actually mean anything. We can discuss it for hours and we will agree at the end, like justice, it can mean whatever you want it to mean. So capital punishment also becomes a bit of a difficult issue, because what happens in truth is that the justices of the Supreme Court, now my greatest respect to the Supreme Court as an institution and the judges, they are, I mean, our leaders, we respect them, but how many of them have actual trial experience? Now, most of them have not practiced at the trial bar. They might have handled a lot of capital punishment caseload as an appellate lawyer before the Supreme Court or the High Court. They might have judged a lot of cases as on a bench in the Supreme Court in seniority, but how many of them actually tried it? Capital punishment is always sought by the prosecution. The judges never go ahead and offer it. So you have to train the prosecutors in which cases to seek it and in which cases not to seek it. Because ultimately, until the time the Supreme Court declares it unconstitutional, which it can't, because there is just no way to do it. You have to stretch Article 21 to a place where it almost breaks down its meaning. So again, to remain consistent, and also I think relying on like public want it, the courts shouldn't be doing it in the first place. Courts can, like, what happens is that public wants it is an ethical value. I don't think it's an ethical value. I think it's a political value. And it can inform political discourse, and it should inform political discourse, because that's what it's based on, what people want, but it shouldn't be informing legal discourse. But the moment it starts to do, the moment public opinion becomes an ethical value, you are in a very difficult position. So having said that, the judges shouldn't be doing it. There should be a higher, more stable grounding principle. That grounding principle, where are you going to find it? You can't find it in any ethical code. So you go back to the text of the Constitution. Text of the Constitution is silent. You go back to Parliament. Parliament says we are not going to repeal it. You go back to, so you see, it's a problem. Capital punishment is a very delicate problem. The best way is to train prosecutors to seek it in only those cases where their conscience would justify it. But that would mean that we'll have to focus on the prosecution department. How many people are concerned about the prosecution departments? What is the proportion of the money that the state governments spend on their budget? I bet if you make a calculation, it won't be more than 0.5% of the whole budget, which will be an abomination. We don't have enough prosecutors. We don't have enough good prosecutors. We have no way to train them, no way to... You see, the problem is at that level. The problem is there, but it has to be fixed at that level. And then when, like, okay, so now there is one particular pocket of the country where more capital punishment awards are coming from. Of course, the High Court is already there, but why are the court? That's where data becomes very important. How much of this data mining are we doing? How much of again, my point, we want to take CRPC, criminal procedure, very seriously, because we are good people. We want this to work, but when it comes to the actual spending of money and resources, we don't actually do anything. So I think I take every point you make in capital punishment that people want it is a very, very weak, very slim. It's a slippery wicket to be, and you can be caught out behind at any point of time. You should be on a more stable wicket on that. But rare of rarest cases will never allow you to do that. Is the Supreme Court willing to rethink it? That is another can of worms. So I hope I've responded to some extent.
Yes, yeah, thank you, sir.
Yeah, I'm Nisha Chopra. I'm also an assistant professor here at the School of Law. Actually, I want to take forward what Shantanu asked. I also have the same question, but with respect to legislatures as well, because you said that the two corollaries which can be drawn from your definition of criminal procedure are that you should be careful in what you're making an offense, what activities are you designating as an offense. And secondly, people should not lose their faith in the whole criminal justice system. But what has happened, not only the court, time and again, the legislature too does that. Whenever there is an incident which shakes the collective conscience, as we say, the legislature runs towards criminalizing, over-criminalizing things and increasing the punishment. That has happened after the Delhi gang rape case also 2013. Within months, they criminalized additional acts and they increased the punishment. So my question is that both of these corollaries, in my opinion, how do you achieve a balance? Like, because we cannot expect the general public to understand the nitty-gritty and the nuances of criminalization. Right? We do not expect them to understand both what laws and what principles go behind criminalizing an activity. Because the general public needs to be, in order to maintain their faith in the criminal justice system, we need to do such activities because we need to criminalize certain activities. We need to appease them. So, because we cannot expect them to understand the nitty-gritty of criminalization and the law behind it and all the academic discussions behind it. So, how do you achieve that balance? Because we definitely cannot expect them to do that. Because when such an incident happens, it appeals to the very basic animal instinct that people want harsher punishment, people want more criminalization. So, how do you achieve a balance between these two corollaries of the definition of criminal procedure?
Balance is always difficult to achieve, as all things in life. That's if one can achieve balance and one can stay there. So I think the question is an important one. How to achieve balance, Isha? It's a difficult question to answer. I think one way of achieving balance is for one to realize that when people demand capital punishment, let's assume a hypothetical scenario where, since you've already mentioned the Delhi gang rape case, let's assume a similar scenario where the blood of the people boils, so to speak. I mean, that captures the sentiment. Why would the blood of people boil is the question that we have to ask as legal academics. I mean, is my blood boiling too? Of course, my blood can boil too. I'm a human being. I see some brutal activity being committed. I mean, one feels a great sense of injustice. One feels connected with the victim. One can feel their pain, and there are certain circumstances which are so diabolical that the entire nation feels the pain. You know, it can happen. Things like this have been known to happen. I think that's a very sad moment, but it's also an important moment to realize that, okay, this is where people are coming together. People will not take it. This is something people have drawn the line. I think that type of moment provides us a very rare glimpse into our collective psyche. And it shows that all our differences fade away. This is where we come together. We won't allow this to ever happen again as a people. That is a tremendous source of strength in a time which everybody is facing great adversity. The tremendous source of strength. That strength needs to be harnessed. If we are not to allow this to ever happen again, what can we realistically do? And I think that is where we lose the battle as a people. Because people come together, there is this great moment. It can come in a positive way also. Imagine if India would have won the World Cup. That's again, it's a moment of, if one is theistically minded, it's a moment of divine grace. It comes very rarely. All the differences are forgotten. People become one. What to do with that moment? That's what people don't realize. I think if you look at the history of reform that has actually worked in jurisdictions that are comparable, I think you will find that it was moments like these when people were suffering a great collective trauma, that the legal system came together and was able to make some suggestions that were workable. Unfortunately, in our case, there was a commission that was set up. The Verma Commission was set up. But again, Verma Commission wasn't given as much time as they should have been given. And therefore, they came up with their report. But again, it suffers from the same flaw. It's the same thing repackaged in different words. doesn't actually solve the problem. I think Burma Commission should have been given more time. They did what they could. They did their best. It's up to us now to take the baton from there and see what we can do and build on that. So I think another way in which balance is to be achieved is not to leave the attainment of this balance to the Supreme Court. We can't expect the Supreme Court to do what we can do in pages of law review. Certain legal discussions are ideal for law reviews and not the pages of the Supreme Court of India reports. But that's what we see case after case. Read Keshwaran Bharti case. It reads more like a law review article than a Supreme Court judgment. It should not be the case. There are many others. I can cite off a few. What law review, debate and discussion is required to do and can achieve, we as academics have left that to the Supreme Court. So we can't say our judgments are overburdened. If we are responsible for it, we should come forward. We academics should come forward, and these are the debates we need to be having in our law reviews. We should not be burdening the Supreme Court with developing these theoretical paradigms. This is our domain. They tell us what the law is. We tell them how theoretically it makes sense. It's not their job. That's what I have to say. It's up to us legal academics to find the balance and then to train our students in that balance. So when they go and practice law, when they become judges, they carry that sense of balance with them. And that's how in a generation's time, hopefully, it's like sowing a seed and watching it grow rather than just spraying some chemical and suddenly it's all. That's not, it's a slow process achieving balance. Yeah. I hope that answers it.
Yeah, thank you.
Any other questions or comments? Professor Khagesh, I don't specialize in criminal law. I specialize in health law, which is my area of interest. But I just wanted to ask you, when you talk about criminal law, if you take cases like Shraddhanand Swami and many other cases where Isha was talking about, something that's very gruesome, which actually starts hitting the personal bias of an individual as well. And on the other side, we also have this, media as a form of entertainment where we have series coming in. It could be criminal justice or it could be dancing on the grave. A lot of times you see that, the kind of portrayal of what a judicial precedent talks and what is portrayed, in the form of a series is extremely, different because, and it's also very difficult to digest at certain point of time. So I wanted to understand, what are your views on that? Because as a layman, normally, or somebody who's not from a legal background, they would probably want to watch those and, make a judgment. So Shraddhanand Swami is a classic example. Like I was watching this series with my family and I knew of the judgment. Literally, I could see my family, completely for Shraddhanand Swami. So you can imagine, it becomes difficult because as an academic where you've learned a little of criminal procedure, you're trying to tell them that, no, this cannot happen. This is something, which falls into the rarest of rare cases. How do you want to respond to this?
I don't find the need to tell people. That's all. I take my Kelsen very seriously. And if I recall, Kelsen said something very profound. I found this to be very helpful, especially in moments like those. It's like, guys, this is not how it happens. Mm-hmm. I found Kelsen, I had that. I was like, I would feel the need. I don't feel the need, I've noticed of lately, to talk about. You see, you have to think, it's not elitism, but it's not elite. We are all criminal law professors. You can talk, it's a lack of shared vocabulary. Yes. Common people don't have the vocabulary that we have. I can talk about Shraddhanand Swami's case with you, and I can talk about a Netflix series on that case with you, and we can simultaneously have both discussions, and it'll be quite fun. But we can't have that with common people because they are not trained in that. You can imagine a physicist not trained in law, and we can't even talk to them because we can't talk physics to them. It's like this. So it's okay to talk about these things within the domain of people who are experts or who are stakeholders or who are engaging with the system, so long as lawyers and judges understand, so long as lawyers and judges are not being misled, then it's okay. Common people are being entertained. Let them be entertained. Today they're entertained by this, tomorrow they'll be entertained by something else. Common memory is very short. So that's one. Second, I don't feel the need to engage. So one copy. So it's like piece for entertainment. It's not a scholarly discussion. People watch this, tomorrow they'll watch something else. make sure you talk about this like, oh, this is not done properly. Or if like something has a huge impact, but that happens very rarely, people forget. Public memory is very short. Second is, if you look at the theory of Kelsen says, if I recall correctly, or at the cost of oversimplification, laws are commands to the judges, legal decision makers mostly. Laws, it's a command. He's not concerned by where the command is coming. He's more concerned with what the command is doing and to whom it is issued. And he said laws are commands to judges, not command to lay people.
Lay members.
So
That's right.
lay people are not concerned with law. Lay people are concerned. Non-lawyers are not concerned with law. If they were concerned with law, they would become lawyers. They're concerned with law only to the extent they interact with the law. The law is everywhere, like oxygen. You can't escape the law. You go into a jungle to do a meditation, there is a Forest and Wildlife Act applicable to you. The law is everywhere. The law is the second best thing that we create the concept of one true God, and second best concept is law. Right? So the law is everywhere. You can't run away from it. I know that. You don't know that. I don't need you to know that. As long as I know the law is there. So that's why there is no need. Lastly, I do believe though that these type of series, they do serve a valuable purpose, because they can open up the imagination of that young 16-year-old child into taking up law very seriously. And to that extent, one wants some accurate representation. But if some 16-year-old is feeling initiated, gravitated towards law, probably they will not base their judgment on some random Netflix show. So to that extent, I think legal academics should seriously think about making podcasts. Podcasts are like radio interviews. Essentially, we should be talking about this, recording those conversations, putting them on a platform where people can access them. So that creates them. And also in the law colleges, in law schools, 5-year law, 3-year law, LLM, we have a lot of students who are artistically inclined, who said lawyers can't be painters or they can't be playwrights. So if we find that spark in a youth, we should probably encourage them to, see, okay, you have read this judgment, can you write a play out of it? Then we can ask the dramatics club to enact that play. For our internal purposes, it will serve a great purpose, and maybe we find a good, law is not all, it's just something that we do. I mean, it's just so. I think we shouldn't be taking things way too seriously. How are people thinking? It doesn't really matter how people are thinking. What matters is how experts are thinking. And experts, we know they're thinking like us. So I don't really feel, I don't feel disturbed or affected by that a lot.
Any other questions? Lastly, is there anything that you would want to let our LLM students who have elective course on criminal law, comparative criminal law, which Professor Shantanu is handling? So a little on that before we wind up.
Is there, Professor Shantanu, is there anything specific that you'd want me to address your students on, or just generally about?
So generally.
So for LLM, I'll share my own LLM experience. I think that'll be the best. So I initially, I had always wanted to do an LLM after I graduated law school. And I went into practice, remained in practice for about 4 years. But I had this in the back of my head always. And ultimately, I was able to make it to Columbia Law School in New York. And when I started my LLM, my whole focus, so this is, so I should probably, this anecdote story is important. When I started my LLM in Columbia, there was a 10-day period where they would only teach like basic courses on American law, and there would be a test after that. We had I don't know if they still do it, but at that point of time, there was an option to take the test without doing the classes, to show that like somebody from England comes, they already know whatever. So I took the test on the second day. I passed the test, so I had 10 days free. So I was roaming around, meeting, making new friends. I met this friend of mine. I met somebody from Australia. I haven't been in touch with him for a long time, but this gentleman suggested a very strange thing, which I found very useful. He said, I'm going to take courses on a particular theme, and I'm going to take 4 seminar courses. In the seminar courses, we had to write a research paper. I'll take 4 seminar courses. I'll write all 4 on largely same things, and later on I'll convert all that into a book. I immediately thought, this guy is very well prepared. He's thinking like, wait, like this is very good. So I sort of followed that same policy. And then I wasn't thinking of getting into academics as such. I had a chance to meet with one of my professors, Professor Jagdish Bhagwati, there in New York. And I went to meet him in the month of February of 2013, when he encouraged me to go back to India and think of legal academics seriously. But in between, I used to attend a lot of talks. And in all these talks, they continuously would stress on the point that a graduate education is to push the envelope a little. So you should focus on research, you should focus on writing, and you should focus on doing something that was called a job talk paper. That's specific to US academic market. That's not how the way it's done in India. We have more, we have more like a PhD thing. You should have a PhD. But apparently JD is a terminal degree, so you don't need a PhD in US. So job talk paper is what is kind of, is a very big paper, 50,000 words, like a quasi PhD thesis. So job talk paper wasn't for me because I wasn't never very interested in the US academic market at that point of time. But that's how I took it. So I took seminar courses. I took very few like test courses in the end, 1 or 2 that I wanted to. And in those seminar courses, I wrote a lot. So I wrote, and when I came back from New York, I had about 6 or 7 papers in a very good state of completion. Almost immediately after joining here in Jindal, on 1st of July 2013, I was in a span of 1 year or so, was able to convert those papers by working on them and by presenting them in conferences and adding more text. I was able to develop them into some good hard-hitting manuscripts. And those were my first publications. And that got me started. And then I started finding myself what themes I liked, and slowly then completely graduated and crossed over into CRPC. And that's all I do now. Don't do all constitutional law I do in the context of this. So that was my journey. So LLM was very important because Columbia was the kind of school where one could take any course one want. We can design your own. And we had a very nice mix of like 2 credit courses, 3 credit courses. Don't have to write a very long paper. One can write a short paper, so on and so forth. Professors were, well, US professors are not that accessible, but it's not like they're not that accessible. You email them, they'll give you time, and then they'll sit with you, but they're more formal about it. We're a bit informal. Students can just walk in, which is a practice I personally don't like very much. I mean, but they shouldn't just walk in. But yeah, we're more, I mean, I would sit and talk with my students on the ground for half an hour, just like that, explain a point to them. In US, they won't do that, but that's our culture. But outside of that, they were very accessible. So I would go and meet with my professors, and I would sit with them, and I would show them my paper. And I would there was one circuit, we had a federal court judge and a top law firm partner teaching us a course on First Amendment focused on journalism, just journalistic rights and all. So very, very good course. I wrote a paper which was in that course that was published later on obscene speech. But they would, I would push this judge to give me comments on my term, like my final paper. And finally, one day he called me from his court. It's like, I actually read the whole paper, and he called me, we spoke for half an hour, gave me a lot of comments, which were very useful. So students should be encouraged to keep on, make sure you go and talk to your professors and sit with them and get your first-hand feedback on the work that you've done. Now, you can't be, and your professor is a busy person. They have a life, a husband or a wife, kids, maybe. You don't have that. Someone has to be a little sensitive, but don't pester them, but be respectful, but sit in the company of professors, get some one-to-one face time with them and comments on your papers. That's that way you will progress towards getting some good publications out. And if you are able to get some good publications out, then you'll be in a position to make a space like, okay, this is what I do. This is my body of scholarship. You can go to any institution with that body. You can make a very decent claim towards employment. Also, so that's one. Second, for courses such as criminal procedure, evidence, corporate law, hardcore corporate law, IBC, for instance, bankruptcy and such, I think practice experience is very important, because these are practice oriented courses. I mean, if you have to be able to know deep inside yourself and feel confident inside yourself without the need for any external validation, that if a sessions trial were to come to you, you would be able to conduct it. You don't have to go and conduct a trial every day to prove a point, but you should have that confidence inside. I know what a sessions trial is, and if asked, I can go to court and cross-examine this witness. I can, and once you have that confidence, that can come directly from experience. You see, experience you can't borrow. You can read my book, I can read your book, you can read my paper, I can read your paper, but I can truly understand if I actually go and actually do it. See, so to get that experience is very important. And I think in the area of criminal procedure, since that's what we're talking about, all of us, anywhere, all Indian academics doing CRPC and evidence work must collectively come to some sort of like mental resolution, which they can publish in shiny paper somewhere, that we as a group believe that it's important for us to have real life practice experience, because that makes us better teachers, that makes us better lawyers, and that helps our students learn directly from our experience, that motivates the good students to take up judicial service probably then, or practicing at the trial side. That sacrifice we'll have to make. All of us will have to push ourselves very hard. And of course, I won't speak about research, I already have, but this is about teaching. So we have to really change the way we teach criminal procedure. We have to use more hypothetical problems. We have to, like, for instance, one of the things that I do here is that to teach like default bail and to teach regular bail, what I have done is that based on some work that I did, I drafted an actual bail application. It looks like an actual bail application. And I give that, there is no fact sheet. This is just bail application. Now you have this brief, now go argue. No time to think, just slam it in front of them, 15 minutes to prepare, now go and argue. Now what happens is, you don't have to rely on the professor on pleadings and conveyancing to teach them how to draft a bail application. You just gave them the bail application's draft. It's right there for their entire life. They read it and they know, okay, this is how I plead a bail application. These are the facts I plead, annexures I attach, these are the arguments I build. And I mean, that's one way to think. That's the way to teach CRPC. CRPC can't be taught by the case method, and taking the case method a step further, actual case problem method. This reform has to happen across all law schools in the Republic. I believe if we do this, we academics systematically like come together, do a national conference, and then agree on some agenda and then implement it. We don't have to wait for the Bar Council also. We can just do it on our own. Then I think in 10, 15 years, we'll start seeing a change. Batch, class after class after class will go. Our own methods will get better. Class after class will 5 or 6 classes once they have revolved. They will be an alumni base. They will be out there looking at things, having been trained in a very different tradition. That's the contribution that I think legal academics, I mean, this is only we can do it. Nobody else can do it. Advocates can't do it. They're busy practicing at the bar. They have a job to do, families to feed, judges, same. It's a job. That's what we are here to do. So I think we, being in a very special position, have to be allowed to cross over the bridge from time to time. We should be allowed to practice law or associate with practitioners, and we should take that practice experience back into class, work on that, write about it, take it back to, and that revolving door policy has to be there. I think that will be good for everyone. And those are my views. I hope that answers your question.
No, more than expected. So thank you, Professor Khagesh, for that. thanks very much for engaging with our students. We also had students from outside of RV. I'm sure they also have benefited. We joined Professor Murthy again, and thanks to Professor Murthy, because he gave me your details and said I know him very well. So normally, I don't prefer to call people unless I have heard them somewhere. So I was like looking at him, and then he said, he'll make you feel extremely helpful. So thank you very much, and you really did that. So we hope to get in touch with you, and meet you in person at RV University very soon. Both Professor Shantanu and Professor Isha, who head the center, of course, will have more to engage with you as well. But we look forward to meeting you. Thank you very, very much, and
Thank you.
thanks to all the participants for taking this time out. And of course, we will also share Professor Khagesh readings with Professor Shantanu, and he will share this with the class and have a discussion. So until then, thanks to all of you. Have a great day. Thank you.
Thank you so much.